Welcome to the first episode of the podcast. Today's landmark judgment is the Supreme Court judgment of Christine Mulundika and 7 others versus the people. Now, the question for determination in the Supreme Court was whether Section 5(4) of the Public Order Act, which granted the police permission to deny anyone who wanted to hold a gathering or public procession. They had to obtain a permit, and if you were denied a permit, you couldn't hold that rally or that public meeting, and it would be an offense under Section 7 of the Public Order Act. But the Constitution stated something different under Article 20 and 21, talking about the protection of freedom of expression and the freedom of assembly and association. It did allow those two, except with the individual's own consent. The Constitution also stated to a certain effect a limitational clause stating that our human rights are not obsolete. To say, in an event that there is a law or there is an act and under the authority of any law, you carry out that act, it shall not be held to be inconsistent or contravene the Constitution if it can be shown that it was done in the interest of defense, public morality, public health, public order. So, hope you got that. Now, this case was a matter that was heard by the High Court of Zambia. It streamed from the Magistrate Court. So the High Court was looking at the constitutionality of Section 5(4) and Section 6 and other provisions. The High Court initially upheld the judgment saying the Public Order Act, Section 5(4), Section 7, were meant to uphold peace in Zambia. And if we had to strike that particular provision out, there would be chaos in the country. So the High Court, decided that it was constitutional. Now, when the matter came before the Supreme Court, they reversed the High Court's judgment. They stated that the Constitution is the supreme law of the land, and the Constitution has granted these particular rights to people to enjoy. So therefore, if an individual is to get a permit, it basically means that without the permit, they can't hold that particular rally and they cannot express their freedoms, and it's not justifiable in a democratic country like Zambia. They based their judgment on a similar judgment from Zimbabwe, where the Supreme Court has also heard such a similar case relating to individuals who were Zimbabwean trade unionists that had held a meeting without getting a permit. The Zimbabwean High Court said it was unconstitutional, and it went against the Constitution. So you don't need to get a permit. So the landmark judgment of Christine Mulundika versus the people, or Christine Mulundika and 7 others versus the people, brought to the fore that the Constitution is the supreme law of the land, and it is from this Constitution, or from our Constitution, that an Act of Parliament derives its authority from. Therefore, if an Act of Parliament is going to be enacted, it must always go back and reflect what is in the Constitution, and that the courts have been given the mandate to therefore strike down a provision of the Public Order Act or any act that is inconsistent with the Constitution. Now, it is very important to remember that the Public Order Act, the whole act was not rendered unconstitutional, no. Certain provisions, because the other provisions were constitutional, because even the Constitution does state to a certain extent that nothing contained or done under the authority of any law shall be held to be inconsistent with or in contravention of this article, which is Article 21 and also Article 20, to the extent that it is shown that the law in question makes provision that it is reasonably required in the interest of defense, public safety, public order, public morality, or public health. The Constitution does state to a certain extent to say there are certain laws that will be allowed because they are looking at the interests of other people, not just you, but other people. So your rights are to a certain extent limited, and they are not full rights, they're not absolute. They are limited. So they said certain provisions were still legal, okay, and that the Constitution allowed them and they were in line with that. But Section 5, which required a permit, was unconstitutional because a permit is more like a license. It is basically an offense that you have to seek permission, which is not true because the Constitution says, except with his own consent, an individual has the freedom of movement and freedom of expression, assembly. So the Constitution stood as the supreme law of the land, and the Public Order Act is subordinate. So the landmark judgment therefore enshrined the principle that the Constitution shall always be the number one law in the country, and that therefore every other law shall be consistent with whatever is in the Constitution, failure to which it will be considered to be inconsistent with the Constitution. So the landmark judgment of Christine Mulundika therefore stated that the Constitution is chapter 1, and that every other law must be consistent with the Constitution, or else it will be inconsistent to the I was trying to use a word, or else it will be void to the extent of its inconsistency. So it also brought to the fact that our courts now have the power, including the High Court, which used to hear constitutional matters, that you could strike a law that was void and was unconstitutional. It also brought to the fold to say every law that is made must be made with the Constitution in mind. It must not always be exact, but you must be wary of the Constitution. So next to it with me, George, I hope you've enjoyed, I hope you've learned something, and I hope you've understood now why people say the Constitution is the supreme law of the land. And if you're asked, why are you saying that? Remember what the Constitution says. It is the supreme law of the land, and every other written law must be inconsistent. And this was expressed in Christine Mulundika and 7 others versus the people. The Public Order Act was not considered void by the Supreme Court. Certain provisions of that act were considered void, and other provisions stood. You will understand as we go along that there has been another attempt at declaring the Public Order Act inconsistent, and we'll look at that. We'll also look at the other elements from the Christine Mulundika case through the eyes of the Resident Doctors Association versus the Attorney General further on. The Public Order Act was amended, I think it was in 1996, reflecting some of the comments that the Supreme Court had given. Like I had stated earlier on, we will look at this case again in depth when we're looking at freedom of movement, freedom of expression through the eyes of the case already mentioned. Today was just about the supremacy of the Constitution, and if an act of parliament is subordinate and does not conform to the Constitution, it will be considered unconstitutional. So, with that said, I want to say thank you for listening and see you next time. Hope you enjoyed the podcast.